Hello and welcome to the Building Podcast. Today, we're exploring what happens to businesses and people when health and safety goes wrong and people end up in court defending their actions or inactions against the health and safety executive. We're really lucky to have leading barrister Ian Bridge, who spends part of his professional life defending people in court, speaking on their behalf to put their side of the story, what is often a very complex issue. I'm really looking forward to hearing Ian's perspective on our industry, in the clear hope that I never have to use his professional services. Ian, good afternoon and welcome to the Building Podcast.
Good afternoon, Mark, and thank you for inviting me.
Not at all. Looking forward to the conversation. Ian, we normally start by giving an opportunity to just say sort of what you do as a day job and who you work for and how it works, so that people got a chance to understand where you're coming from and the experience that you can bring to the conversation.
So I'm a barrister. I'm a member of Chambers. The Chambers I'm a member of is called Number 5 Chambers. We have premises in Birmingham and London and Bristol, and we have nationwide practice in all sorts of different areas. I've been a barrister for a long time now, longer than I care to remember, about 35 years. And I've found myself acting in cases usually where there's been a serious injury or a death, often involving deaths at work, serious injuries at work, but also very frequently involving accidents on the road. In addition to that, I have other practice areas, and in particular in relation to fraud and VAT. But for today's purposes, it's fatalities and serious injuries in the workplace, which I think we're going to be talking about, Mark.
And we are indeed.
I should say that for many years I prosecuted on behalf of the HSE, and I no longer do that. I now only act on behalf of those facing prosecution. So that's me.
Brilliant. Well, that positions it very well. I think we all know what we're dealing with today, or at least we've got some idea. Let me ask a sort of fairly simple question to start in, because I think not all cases end up in court, do they? So not all health and safety failures that we might see on site end up in court or being prosecuted. Is there a sort of a rule of thumb or advice that you can give to sort of what the HSE might bring to court and what would be sort of left alone? Is it sort of like first cases you're given once off, or is it just the integrity of the evidence or what's actually happened? Is there sort of a guidance you can give on that?
Yeah, I mean, I should say in an ideal world, the HSE is properly funded, and there are lots and lots of inspectors who are fulfilling the role of visiting businesses and advising them on health and safety issues in all different spheres, not just building, checking up on them and making sure that there's nothing obvious going wrong during the course of a visit. I think it's fair to say that we don't live in an ideal world, and there aren't that many inspectors. And so whilst a lot of inspections are undertaken, in truth, enforcement, that's to say prosecution or other lesser enforcement, usually takes place following either an accident in which somebody's been injured, or even worse, an accident in which somebody's died. The first thing that you as an employer have to do once that happens is notify the HSE that there has been an accident and that you have what the circumstances are. And to fail to do that in and of itself is likely to bring down regulatory approbation. Having notified them, it's likely that you will be visited by them, and if there's a fatality or if there's a serious injury, the police will attend upon your either building site or premises or both, and the whole process will begin. So going back to the question, what are the circumstances in which you as a builder are likely to encounter the HSC. I'm afraid most commonly in my experience, I may be wrong about this, but in my experience, most commonly, it's where there's been an accident or where there has been a fatal accident. And that will provoke an investigation. What happens thereafter is usually delayed, takes a long time to investigate. But the decision as to whether or not you end up on the wrong side of a court depends upon a lot of factors, which I can go through.
Well, what would the main
you.
ones be in? Would they be, are they, is it track record? Is it?
Well, there's a published framework, and I have to say that one of the best resources for years now on the on the internet has been the Health and Safety Executive's website. It's an excellent website and is very thorough and very detailed. And in that on that website, you'll find the enforcement management model,
Right.
and lots of other bits and pieces which will educate you as to the detail of how they go about deciding what they're going to do in any particular case.
Yeah.
But you're quite right to focus on record. I mean, looking at it from a very basic point of view, it's like any other crime in a sense. So when the Crown Prosecution Service or HMRC or any other prosecuting body are confronted with a potential criminal offence, that they apply what's known as the code test. The code test involves an assessment, first of all, of the strength of the evidence and answering the question, are a jury likely to convict? If the answer to that is yes, based on the evidence, there's then a second stage, and that involves answering the question, is it in the public interest to bring a prosecution? In the case of a fatality or a serious injury, I think you will almost always find that it is in the public interest, or it's felt to be in the public interest to prosecute if the evidence is there. Not least because you're likely to have a victim who's either suffered really serious injuries, which they're going to have to live with, or you're dealing with a grieving family. Yeah. So it's almost always the case that there's a public interest in prosecuting. Where you haven't got a serious injury, or where the problem doesn't involve a serious injury or a fatality, there are other options. And even on occasion, the EMM will, it always requires an assessment of the situation. And you can have injuries which occur, and you can have different people being investigated. So premises owners versus contractors on premises, and the usual scenario where, particularly with building, you have subcontractors, so a whole chain of self-employed individuals, and businesses at various stages doing groundworks, ranging from using a shovel to much higher up the chain, doing more complicated things like design. All of those characteristics are thrown into the mix in determining whether or not enforcement action needs to be taken. So at the bottom end, there will be the giving of advice, and the way in which that advice is given, again, depends on how appropriate it's felt to either have a word with somebody or write a formal letter. Words of advice saying, please make sure this is dealt with, and we'll be coming to look at you again.
Yep.
You've then got prohibition notices. So in circumstances where, for example, there is an ongoing danger, there's really an obligation on the HSC where they come across that to prevent that danger from continuing, and they will serve a prohibition notice, which will have a deadline and require the receiver of the notice to act to stop the danger from continuing. There's a whole rather cumbersome procedure whereby you can appeal that notice.
There is, yes.
Bizarrely goes through the employment tribunal, and you'll often find yourself in front of an employment judge who is not terribly familiar with the jurisdiction that they have to deal with appeals on prohibition notices. There's also an improvement notice, which is a lesser notice than a prohibition notice. An improvement notice is where the HSC feels that training is required, or that there's something else that you can do to ensure the safety of your workers, or to ensure that your undertaking is conducted in a way which ensures the safety of third parties. They can require you to improve. And again, that notice can be appealed by means of an appeal to the employment tribunal. I should say all of this as well is paid for by the transgressor or the potential transgressor. So what's known as an FFI, or a fee for intervention, is likely to land upon your desk soon after the involvement of the HSE, which covers the costs that they've incurred in having to regulate you after becoming involved in an investigation against you. And that's a separate thing from court costs, which are payable in due course. But I have to say, my experience is that where there are serious injuries on building sites, and you are either an employer or a principal contractor, or a nominated party within the construction design management regulations, then my experience is that you will do very well to avoid enforcement by way of prosecution, particularly if there's been a fatality. But even if there's been a relatively minor injury, then usually prosecution will result, in my experience. But every case is different, and if you've got a good lawyer on board, they will make representations before the HSC reaches a conclusion as to how they should be using the EMM and applying their guidance and the more generic guidance on prosecution, and pointing out where the weaknesses and strengths are in the case.
Do you want to just say what EMM stands for, so that everybody...
Enforcement Management Module Method, EMM,
Method.
Enforcement
Method.
Management Method.
Method, I think, isn't it? Yes.
Yeah.
So it sounds. I mean, we've been through the escalation of HSE actions that they can take there, which is, and as you say, ends up, if the glove fits, ends up in court and court action. And do the HSE generally take companies to court, or are they taking directors of those companies to court? I mean, clearly in both cases, the director's got to stand up and be counted. But is it a corporate, in most cases corporate, or in some cases directors?
It very much varies. I mean, it used to be the case that it was there was a clear focus on the corporate rather than the individual. And where you ended up with individuals, it was, in my experience, situations where individuals had maybe got their mate along to help them on a small job, and there'd been an accident. But I think in recent times there's been a much greater focus on directors and directors' responsibilities. And and there are different offences for individuals. So there are duties on individuals and managers and directors within businesses. There are two generic offences. There are an endless number of regulations. The obvious ones for the construction industry, the construction design management regulations, which put in place a framework which I would hope that most of your listeners are very familiar with.
Yep.
And not applying CDM strictly is a big no-no, and it's very important that, and I'm sure it is the case, that most construction workers are familiar with the CDM regulations, the obligations that there are. And one thing that is not widely known actually is the breadth of the application of CDM. And it's come across my desk recently that a job which I think most people would not regard as construction, in which there was a dreadful accident. It was an engineering task, but a big engineering task within a site, is covered by CDM. So even if you're replacing a machine, or amending or repairing or servicing a machine, there's a very good chance that CDM regs will apply. And you need to be astute to that if you're an engineer, because you will find that a lot of engineers are not. They'll arrive at a site and they'll be doing something which is an engineering task on a dictionary definition, but to which, on the definitions which apply in the regulations, is construction design management, and therefore those regulations apply.
We found that very much in the energy world, is that, having come from construction and moved into and now working in energy, I find that CDM is one of those things that people don't really understand, but they have to be told a couple of times that it is a statutory requirement that will catch them out badly if they get it wrong.
Absolutely. And you need to be very clear who is where within the ladder of responsibility within the regulation. So who is the principal contractor, and who all the other various individuals are within, and where the responsibilities lie, where the duties lie, according to those regulations, and a failure to apply them and be clear about them can land you in hot water should there be anything go wrong. Just going back to your question as to individuals versus corporates, and one of the things that happens is obviously companies can't speak for themselves. They speak through the mouths of directors or managers. Directors and managers will often be called to interview under caution. Frequently what happens these days is that isn't done in the way in which you perhaps would expect it to be done. You would often have a series of questions written out in a letter, and the response prepared in a letter, which is done effectively as answers given under caution. There is also another important difference between health and safety and, as it were, normal crime, in the sense that the powers which exist for the HSE and local authority investigators are under the Health and Safety at Work, etc. Act 1974. They include Section 20, which is what's known as a compulsion power. So you can be compelled to answer questions if you don't answer them, and if you don't answer them voluntarily, and if you don't answer them voluntarily, and you are compelled and you still don't answer them, that is in and of itself as a crime. But you have the notional protection if you are compelled, which is part and parcel of your human rights, to be able to know that the answers that you provide can't be relied on as evidence against you. So compulsion, the trade-off for compelled answers is that you've no need to worry about those answers being used against you, although it's often an illusory protection because it doesn't generally apply to pre-existing statements or documents. And if you say things under compulsion which direct the HSE in the direction of pre-existing documents, notes, or other written evidence, then even though those answers have been compelled, those other documents are admissible and can be used against you. So HSE have got, be perhaps surprised to hear, stronger powers than have police in that sense. And they're akin to powers that the Serious Fraud Office have under a different piece of legislation in relation to compulsion. And there are various other regulators that have compulsion powers. The HSE have them. So you need to know if you're being interviewed as a director, whether you're being interviewed qua director or as an individual. And so you need to know, need to ask, that needs to be asked by your lawyer. I think that's probably all there is to say. I mean, there are, without the act in front of me, I'm not really in a position to reel off the
no, we don't need to reel off it. we can get
offences that individuals can face as opposed to corporates. And Section 37 is one. There is an offence which directors may well frequently face, which is consenting, conniving, or neglecting to prevent the commission of an offence by a company, rather than actually breaching a duty. So, and those consent, connivance, and neglecting to prevent are different degrees of culpability. Really, it's the same offence. Neglecting is failing to do it even though you know it needs to be done. Conniving is something less than that, a bit of a Nelsonian blind eye, I think. And then neglecting to prevent is really negligence. So that's one area in which directors, managers, and others can find themselves on the hook. But there are specific duties that individuals can also find that they face if they are clearly involved in a breach as individuals.
And that's not just directors, is it? That can be senior managers. So in our case, site managers can find themselves in front of the court where they've clearly breached the legislation.
Yeah, it can be relatively lowly employees. As long as they have a responsibility and control and a duty, then yes, they can find themselves in difficulty.
Now, nothing you've said so far, Ian, would say there's a difference, or the HSE treats the size of the transgressor any differently. So big companies will be treated the same as small companies. They're just perhaps different levers and different areas they're going to look at for a big company as opposed to a small company. Do you think that's generally the case? Is that everybody's equal in the eyes of the law?
No, it isn't, and it specifically isn't in relation to, for example, RAMs, which many of your listeners will be.
We're all about RAMs, yes.
Phrase. So risk assessments, method statements. So it's very good practice always to have detailed written risk assessments and method statements following. And the number of times, if I had a pound for the number of times I've heard the word generic used in the context of risk assessments, method statements, I'd be a wealthy man. It's not good enough just to get a consultant to prepare a document which ticks the boxes in terms of assessing the risk. You actually need to be able to demonstrate that you've sat yourself down, thought about what the risks are in relation to a particular task, written them down, carefully thought about them, and thereafter carefully devised a method which, so far as is reasonably practicable, enables safety, ensures safety to be achieved. Why am I mentioning RAMs? I'm mentioning RAMs because depending on the size of your enterprise, they either need to be written and detailed or not, which is another regulation. So there's definitely a difference, a statutory difference in terms of what's expected.
Right.
From that point of view, there's also a difference in the sense that the HSC, when looking at enforcement, have to, I think, as generally do all enforcement bodies, have to look at things proportionately. So if you're a small business with maybe one or two subcontractors that regularly work with you, then the standards, and more particularly the investment that is necessary for you to meet the standard, is inevitably less than it would be for a much larger business, which has the resource and has the ability to put more time in it, more risk, frankly, because there's more people and it's a bigger enterprise.
Yeah.
So I would say no, that the law deliberately and consciously discriminates between large businesses, of whom more is expected, and small businesses of whom a high standard is expected, but I suppose it's a different type of thing that's expected of them.
Yeah.
So it often won't feel like that if you're a small operation and one of only two or three of you has either been very seriously injured or killed, because you will still be prosecuted and you will still find yourself on the wrong end of the law. But there is a real difference in terms of approach, or there should be. It's proportionate. It needs to be proportionate.
Yeah. Well, I think that makes a lot of sense, doesn't it? As you say, large companies dealing with many more people must be exposed to a higher level of care to those people.
Yeah.
And that would be right. And I suppose the other area, which is obviously different, is the sentencing guidelines. If you're found guilty of a breach,
Yeah.
it varies for depending on the size of the business for some, for obvious reasons.
Yeah. So the Sentencing Guidelines Council publishes online another very good website if you want to frighten yourself if you've been in a situation where you might be facing enforcement, is the Sentencing Guidelines Council. They have what they call generic or overarching guidelines, and there are, I don't know, maybe 10 of them. But there are specific offence guidelines, a whole long list of them.
Yeah.
And there's a specific guideline for health and safety offending by individuals and by companies. And there's the overarching guidance identifies two areas upon which the courts are obliged to focus when imposing a sentence. Actually, before I deal with that, just going back to the difference between companies and individuals. Obviously, you can't lock a company up, but you can lock an individual up, which I didn't mention.
Yeah.
And that's a difference in risk. But jumping back, if I can, to sentencing guidelines, which deal with individuals and the circumstances where a sentence of imprisonment is appropriate. But dealing with companies, the two areas where the sentencing judge has to focus is, in the first instance, culpability. So how blameworthy is the company for what has happened, for failing to ensure safety, or for conducting their undertaking in a way which failed to ensure safety? Is it an egregious, obvious, serious breach which was designed to make a profit? In other words, did you fail to buy that bit of safety equipment because it was expensive and you'd rather risk people's lives? That's a serious, obviously very serious, culpable, highly culpable offence. Whereas at the other end of the scale, looking at culpability, you can have a situation where everything's available and everything's been done. All the training is in place. It's just that there's been, for one reason or another, on a particular occasion, a failure to do maybe often just one thing, which has resulted in a tragedy. And that obviously is much lesser. And then once you've established culpability, there are various other things that you need to look at. I mean, how many individuals were put at risk by the breach is one thing.
Yeah.
But all of this is set out in the guideline.
Mm-hmm.
The second area beyond culpability, which the court must look at, is harm. Obviously, if it's a fatal incident, the harm is at the highest level.
Yeah.
You've killed somebody, so there's not much more to be said about that. It's not just who you've killed or who you've injured. It's an assessment of risk.
Mm-hmm.
So the harm is obviously it's aggravated by an actual death or an actual injury, but the harm is how much risk did you create? So in failing to ensure safety, how risky was your behaviour? And then once you've assessed, I think there are 4 measures of culpability, and I think 3 measures of harm. Once you've assessed which measure of culpability you have and which measure of harm, you then apply those measures to a matrix. The other thing which you have to put before the court is ideally 3 years worth of the latest sets of accounts, from which the court will make an assessment of your turnover, and it is turnover rather than profit.
Yeah.
Profit can be taken into account if there's a particularly difficult year, but the figure which puts you in the bracket which matters is your turnover. And if I'm not mistaken, and I may be, I mean, you can see this online, there's micro, small, medium, large and very large, and I think the figures were, I think up to 2 million is micro for turnover, then I think it's 2 to 10, 10 to 50, and then above 50 million is considered to be a very large business. But it doesn't take many houses being built for you to find yourselves in that top bracket. In reality, and relatively small building companies, necessarily because of the nature of the work they do, can easily find themselves quite high up the ladder in terms of turnover. So sentencing guidance is obviously critical, and one of the most important bits of advice you'll get, and you'll need it early on, is as to whether or not you want to try and retain any credit for plea. So make an assessment of how likely it is, given the evidence, that you're going to be convicted, and then make a decision about whether or not you want to try and contest the allegation in the hope that you'll be acquitted, in which case your fine will be 0. You may still end up with quite substantial costs, but whether you're insured or not is another factor you'll have to take into account. If, however, you are convicted after deciding to plead not guilty, you will then pay 1/3 more than you would in fine if you pleaded guilty, as well as the costs of a trial. So in fact, it often boils down to, in my experience, a commercial decision.
So that explains then why many cases end up with the defendants pleading guilty before they get to court, and that's to avoid that 3rd increase in cost.
Well, they can't plead guilty before they get to court, but they can plead guilty at the first opportunity. So that will often be in the magistrate's court at the first hearing when they indicate a guilty plea. And if they enter a guilty plea or indicate a guilty plea at that opportunity, at that time, then they're entitled to full credit. There's then effectively a sliding scale to the point where if you plead guilty at the door of the court on the day the trial's listed, you'll probably be lucky to get 5-10%. And then there's a range in between. And obviously, if your lawyers can negotiate on your behalf a plea deal which wasn't on offer at the outset, then you may retain your credit. But if you want, I mean, the courts are very strict on this now. If you want full credit, which is 1/3 off, the time to plead is at the door of the court. I mean, usually with health and safety prosecutions, you will have had a long time to think about that,
Mm.
because very frequently the investigations in these cases go on for years, unfortunately.
Well, I was going to ask about that, Ian. I mean, I think, we hear about the delay in the court processes and how busy the HSE is looking at the cases they have. Do
Yeah,
you want to sort of just give an idea about the process that goes on? So an accident happens. How long is it before you might end up in the magistrate's court as a first port before you then get taken to the Crown Courts?
it's rare for it to happen within 12 months. And I've had cases where it can last as long as 3 or 4 years. Um, so
And that's just before it gets to the magistrate's court, or is
yeah,
that?
yeah, it is. And these cases are not top priority next to rape and murder, and we've got 60,000 cases outstanding in the Crown Court. So you will frequently have another year or so in the Crown Court. So it's a long, long time. It's a terrible drain and a huge upset for everybody involved. Um,
I
but
mean, that's not that's
until it's
sorry.
happened to you as a builder or an employer, losing somebody on a building site or having them injured is something that I've never come across a director or a manager who who isn't very badly affected by that in terms of upset and everything else. It's a
So not
disaster.
only is it a drain on the business and huge distraction for the businesses. I mean, that's you're talking about 4 or 5 years there.
Yeah,
It's also 4 or 5 years of very strong mental health or pressure on those directors who are running
yeah,
that business
yeah.
for sort of.
It's a disaster, and oftentimes, it depends on the size of the enterprise often, but with a smaller business, oftentimes the deceased is a personal friend, not just a colleague, but
Mm.
um, so it's a terrible strain.
Yeah. Okay. And I suppose just for completion's sake, I mean, the first sort of judicial process is a coroner's office is for a fatality, isn't it?
Well,
That's
these cases are referred to coroners. That's a whole different story. Um, I'm afraid my experience is that coroners are frequently used these days by the HSC as part of the investigation. Um, it's a struggle because the coroner wants to get the inquiry done quickly, but the coroner traditionally would want to stand behind the criminal investigation. Um, and so the coroner's inquest is opened and then adjourned, usually and properly behind any criminal investigation. Um, to do otherwise, you risk a situation where people don't feel able to give evidence freely in a coroner's inquiry, and that's bad, because the thing that the family want more than anything else is to understand what's happened to
yeah.
their family member who's died. And if people are standing there saying no comment or I can't answer, it looks dreadful. It's a
Mm.
terrible situation. So usually, although the coroner's inquest opens, it's usually adjourned and it stands behind, and nothing happens until the criminal case is concluded. Um, so it's another aspect to it.
So we've talked around about how busy the courts are,
Yeah,
and how long it's taking. 5 years to get to the proper courts where it's going to get assessed in the Crown Courts.
yeah.
Is that affecting justice at all? Is justice being affected by these delays?
I should say 5 years is a long time.
Yeah.
Most cases are sooner than that, but nonetheless, we're talking about years rather than months. Is justice being affected? Yes. I mean, ideally, the sooner justice is dealt with, the better. Justice delayed is justice denied in some sense.
Hmm.
If you're dealing with a situation where a company is facing a hefty financial penalty, um, then time enables the company and the directors to make arrangements to be able to pay that money. Um, and I suppose, therefore, it's not necessarily um, always such a bad thing. Um, it's it's to my mind, what it does and why it's really bad is that if you imagine from the point of view of either somebody who's been seriously injured or a family that have lost somebody who's been killed, then from their point of view, to have criminal proceedings and a coroner's inquest in the back of their minds, whilst also having to deal with the grief or the pain, just makes a terrible situation worse.
Mm.
And on a completely different level, in other words, nowhere near as bad, but nonetheless, depending on the makeup of the individual, a worry, a stressor, something that can cause anxiety. The directors and the employees who have to give evidence, all of those individuals are also seriously affected by delay. And so it's a bad thing. And the sooner we get to a situation where these things can be dealt with in the courts, at least promptly. And also, I suppose, investigation stage. So I don't want to get political, but the court service and the HSC are both public services, and they have to be funded and funded properly. And if they are, then they can work efficiently and well. And that's all there is to say about it, really.
Yeah. And do you see many companies go to the wall as part of a successful prosecution? I mean, do companies struggle to exist after a major prosecution in the courts, or do you think most of them carry on without?
Well, I tend not to be in touch with them afterwards, but I don't think. I mean, it's not. There's no conscious lack of communication. It's just that your job's done. Your job's done. But I haven't seen businesses go to the wall.
Okay.
But there is a very clear section of the guidance, as I recall, in relation to, I think, corporate manslaughter, but it would apply more generally that if an offence is bad enough, in other words, if we are dealing with a situation where corners have been deliberately cut in order to save money and somebody's lost their life, or that kind of level of culpability, then the courts are clearly advised, I think, within the Sentencing Guidelines Council. I've never had a case like that, but that you shouldn't hold back from imposing a level of penalty which does, in fact, render the business insolvent and prevents it from continuing to trade, because it doesn't deserve to, frankly.
Yeah. Oh, well, that makes some sense. Ian, we've had a good canter through, the processes and what happens in courts. Do you want to just talk us through what somebody who finds himself in this situation of going to court? There's been a health and safety accident. The HSC are prosecuting. What should they do? What's the sort of the best practice to cope with that?
Well, I think the most important bit of advice that I can give is before that, and it's when the accident happens, and it really is to look at your insurance policy and check whether or not you're covered for legal protection. You almost certainly will be.
Yep.
Make sure that directors are also benefiting from D&O cover, and then go to a solicitor and get the solicitor involved at the earliest stage. The benefit of having a lawyer involved at the early stage, rather than just dealing with it yourself, investigating the matter yourself, is that a lawyer will afford you the protection of legal professional privilege for the advice that you get, and advise you from the earliest stage as to how best to approach this. I mean, oftentimes it's axiomatic, isn't it? If you've been in charge of a building site where there's been an accident, and you then investigate the scenario with a view to doing the right thing, which is making sure it doesn't happen again, then you're almost certainly, in reaching that conclusion or in taking steps, acknowledging that steps hadn't been taken previously.
Yeah.
And all of those conclusions, those reports, those internal investigations are all material which the HSC can get their hands on in due course, unless you've you've undertaken the investigation and with the supervision of a lawyer. And if that is the position, then, maybe you're guilty, and that's what you should do. And it will stand to your credit that you've investigated and done the right thing after the event. But I think the most important thing I would say is to get yourself a good solicitor, specialist in health and safety, right at the outset, and make sure that you're receiving advice and following it from the earliest stage. And above and beyond that, I'm not sure, apart from making sure that within your construction business, there's a very clear line of responsibility from board level down through management and right down to the youngest recruit. There's a very clear line of duties, responsibilities, training, and everything else. Because then, if you've got that in place, even if there is a disaster or a tragedy happens, you're likely to be able to say, well, I did everything I possibly could in a dangerous industry to ensure that people who I employed or people who were on my site were safe. And therefore, even though it's something we've not mentioned, but there's a very low bar for health and safety offending, because unlike most crime, the burden of proof is not on the prosecution. Once there has been an accident or a breach, effectively there's prima facie a case to answer, and it's down to the defendant to prove on balance rather than the prosecution to prove beyond reasonable doubt, or so that they're sure that they have done everything reasonable to ensure safety, everything reasonably practicable. And again, that practicable aspect to it feeds into another question you asked me earlier. Practicability. Well, what's practicable for a huge business with lots of resource is different than what's practicable for a small business with much less resource. So it feeds into that aspect of it. But those are the two things I think I would say. I mean, first of all, if the nightmare happens and you do end up with a serious injury and you end up filling out a RIDDOR, notifying the HSC of an offence, get yourself a good solicitor early on. But even before that, make sure that you've got a really good spine running through your business, starting at board level and running right the way down, of health and safety awareness and training, so that even if an accident, which is a genuine accident, takes place, you're then in a position to defend yourself from a regulator who will be looking to make sure that you've done everything to ensure that there was a safe working environment.
And if you've got that spine in place, clearly the accidents are less likely to happen in any event. You've got
exactly.
You're going to be far better off in terms of making sure those accidents don't happen. Ian, it might be worth just saying a little bit about a good. You mentioned get yourself a good solicitor. Now, for those who never have accidents and then suddenly one comes and happens on their doorstep and they've got to do something about it, how do you define a good solicitor? Because presumably you see the results of poor solicitors in your line of work as well, where the proper advice hasn't been given. How do you go about making sure that good?
I can't possibly begin to name individuals on.
No, I can possibly ask you to,
and I won't. But there are resources online which identify solicitors specialising in health and safety. They are relatively well known, and you will find likely that your insurers will steer you in the direction of somebody who they trust and who is on their panel. It's very rare for the insurer's interest to diverge from your interest. And the solicitor's under a duty to make that clear if it happens. You may end up in a situation where if there are employees, different employees, and different subcontractors at different levels, there are potential conflicts of interest. You may end up in a situation where the solicitor says, well, I can act for you, but not for you and you as well, that your interests diverge. You can see easily how one person who might be liable starts to point the finger of blame at another, and clearly that those two individuals can't be represented by the same lawyer.
Yeah.
But I think probably that the advice to be given there is to speak to your broker, notify that you've got this issue, that you need a solicitor, and that you're going to have to make a claim, and see where you end up. You are likely to end up with one of a number of very well-known specialists, and you'll be able to look them up and meet them and size them up for yourself, and then make a decision.
Yeah.
And they will, if it comes to court proceedings and you need to be represented in court, then it's a similar process to barristers, except that we're a referral profession. So there are certain solicitors that will come to me and certain solicitors that would never brief me in a month of Sundays, but that's their choice. And, you don't really, well, it's up to you. You meet your counsel and you make your decision as to whether or not you're happy with the approach that they've adopted, the advice they're given, their manner and everything else. And you can always express a view that you want to change, if that's the position.
They are representing you in court. I mean, your job is to represent that individual or that company, isn't it? So you presume you have to be so comfortable that you're on the same wavelength and understand where they're coming from. It's a confidence issue, and by and large,
it is. But usually, if you've got a solicitor and you're happy with the solicitor and you've been under investigation for quite a while, and they've made representations on your behalf, they've dealt with questions asked you under caution, you'll have developed a relationship with that solicitor whereby you can say, do you know that barrister you sent me? I'm not keen on him. Is there anybody else?
Yeah.
Or vice versa. And that's the way it works. And you'll find people with whom you're comfortable and happy. But that's the way to choose a lawyer. So I think listen to insurer, initially broker.
Yeah. And just for the sake of completion, it's generally the solicitor that's going to recommend barristers like you, rather than having the individual having to go and find their own barrister these days. It's a recommendation that way. You mentioned there vice versa. Do barristers ever reject their clients or not?
Well, we've got various sort of rules about that. I mean, there's a rule called the cab rank rule. I'm not sure. The reality is that if somebody comes to me and wants representation and I'm available and they're willing to pay the fee that I've quoted, then I'll represent them.
Yeah.
And that is the approach of almost every barrister I've ever met.
Yeah, as it should be, shouldn't it?
However objectionable the individual may be, you get on with it and do your best for them.
Yeah, it's a discussion you and I have had offline, isn't it? That actually, when you're up against the state and the state is prosecuting, no matter who you are, you need to have a competent and capable defence, because the state has unlimited resources, and that's it.
Yeah, that's certainly the case.
Yeah.
I mean, and health and safety work at the bar, and I think to some extent in the solicitor's profession, is a relatively small field, particularly contentious work. So most solicitors and barristers know each other from previous dealings. I'm not sure that really matters much, but it is the case. It's a relatively small world.
Yeah, and we've heard it from you. Although you're acting as defence and defending the people, we mustn't forget at the end of the day we're there because there's been an injury or a fatality, and there's it is the worst offence. It's people are being affected, and people are being affected permanently by what goes on, and that's we mustn't lose sight of the seriousness of the accidents that happen. So it's really important that these are dealt with appropriately, and and probably swifter than you're telling us it is currently being dealt with. But
In many cases, yeah.
yeah. Ian, we've had a great run through everything. This goes out to the construction industry, the energy industries. What would your sort of parting shots be, or a bit of advice for people who you see coming onto your doorstep, or ending up in court where you're defending them? You say, well, if only they thought about or done this differently, we wouldn't be here, or we would have done this better. Well, what might you sort of suggest to people as a way forward?
I'm not sure there's anything else to add, Mark, to the 2 points I've already made. The number of times I've had directors say, I wish I'd done this, and invariably it's nothing to do with the prosecution. It's nothing to do with the court appearance. It's to do with taking a step which would have meant that they're not having to deal with the loss of a colleague or a friend or an employee. And that, at the end of the day is what's most often expressed as a regret by clients of mine. It's got nothing to do with the way the lawyers have handled it or what's happened in court. I mean, there's often moans about the length of time it's taken. But with the sentencing guidelines, roughly what you're looking at if you plead guilty or if you don't.
Yeah.
That it's no longer a sort of, put your hand in the air and which way the wind blows is changeable. You do have a very good idea of what you're looking at in terms of penalty these days. So, the process is painstaking, long. There's problems with coroners interacting with Crown courts, and how do you deal with the inquest if they insist on going ahead, and all of that sort of stuff. But all of it pales into insignificance next to, the question of why on earth didn't I insist on that man moving that trench box along a little bit further before the wall collapsed, or putting the barrier around that lift shaft, or making sure that the toe boards were on that scaffold properly. There are so many things that can go wrong on a building site. It's just very difficult to make sure that you do everything properly. But that's the regret which is most expressed to me.
Yeah, and I think that's probably a very good note to finish on, Ian. It's bringing it back to the practical realities that we all deal with on site, is that health and safety process and procedures are absolutely crucial for making sure we don't end up, in your world, defending things which go on forever and defending really bad outcomes for everybody.
Yeah.
But no, that's great. Ian, thank you very much indeed for your time this evening. Been an interesting tour through the legal process of prosecution. I'm sure we've got some interesting facts there for listeners, and thank you very much for your time.
It's an absolute pleasure, Mark.